Yeah, I want to thank my partners for leaving me 6 minutes, and thanks, Mark. Good morning, everyone. I want to thank my colleague Bonnie Chan, first off, for her assistance in drafting the paper and the materials. It's an excellent paper. I commend it to you. As many of you know, we recently opened up a Hamilton office, and we're all very excited about that. And while this was going on, I had the good fortune of traveling to Hawaii on a very special mission. It was to see whether it would be suitable to open up a Hawaii branch in Maui. And Bonnie kindly agreed to draft a paper while I was away. It took me 2 weeks to get a good flavor of the Hawaiian Islands, actually about 2.5 weeks, and my clients were a bit anxious about this. It's the longest vacation I've ever had. It was spectacular. I recommend it. One of the things, though, I determined was there aren't very many unions out there. So unfortunately, I came to the conclusion that it really isn't a great place for us to open up a new office. But while I was there, I did think it would be an excellent place to hold the firm seminar in 2014. So I haven't had a chance to run this by my partners yet, but we've always worked on a kind of consensus model in our partnership and in the firm. So I thought maybe I'd run it by you and see whether anybody here thinks this would be a good idea. So can I see a show of hands for all who are in favor of the Sheraton Hotel next year, 2014? Okay, thank you. And all in favor of holding the seminar in Maui? Hands up. Okay. Looks like we've got a consensus. That's great. I'll just talk to our managing partner, Paul Young. I'm sure he'll be delighted to foot the bill for this. So in any event, my topic for today is to provide you with an overview on an important case that was released earlier this year by the Ontario Court of Appeal relating to occupational health and safety accidents. Now, the geographic scene of the case is decidedly different from the sunny Hawaiian Islands I was enjoying about a month ago now. The case arose out of an incident that occurred at Blue Mountain Resort just outside of Collingwood, Ontario, just north of Toronto. Now, as many of you know, Collingwood is a year-round resort that it largely supports Blue Mountain Ski Resort, which will have 42 runs by this winter. Now, the Occupational Health and Safety Act imposes an obligation on employers to report certain workplace accidents to the Ministry of Labour, among others, union and others, if you have one. And the Blue Mountain decision dealt with the question of whether this reporting obligation applies to non-workers who suffer accidents at an employer's premises. Now, before discussing the obligation imposed on the employers in terms of reporting and preserving the accident site, it's important just to briefly review what the point and purpose of the health and safety legislation is. It's remedial legislation. It provides for a minimum level of protection for workers and workplace health and safety. It establishes procedural and substantive obligations on employers and constructors, supervisors and workers. Ministry of Labour inspectors are responsible for administering the Act, which includes enforcement, inspection, and prosecutions if you're unfortunate. Ministry of Labour inspectors have wide powers as well. They have the power to enter your workplace, to inspect it, to conduct tests and interview your employees, and to issue orders for compliance with the legislation when it's determined that you're not in compliance. Now, accident reporting, though, is my topic for today. The OSHA imposes an obligation on employers to report certain workplace accidents directly to the Ministry of Labour. Specifically, Section 51 of the legislation imposes procedural obligations on an employer where there is a death or a critical injury, they call, from any cause at the workplace. Now, there are two parts to this obligation. The first part is a reporting obligation. You have to contact and talk to the Ministry of Labour right away. You phone in, there's like a hotline, and they'll assign it to inspector. And then within 48 hours of the accident, the employer must send a written report of the circumstances of the occurrence in the workplace to the ministry. The second obligation relates to preservation of the accident scene. You're not allowed to interfere with or disturb or do anything with the accident scene until the Ministry of Labour comes out and ultimately gives you permission to do so. And the purpose of that is to preserve evidence or potential evidence that might be needed to be reviewed to determine whether or not the Act has been violated and whether a prosecution should be brought. The obligations under Section 51 are intended to further health and safety in the workplace by reporting a workplace death or critical injury to the ministry. The ministry inspector can then come to the workplace and conduct investigation, interview the witnesses and employees, and determine what steps, if any, need to be taken to minimize risks to employees in the future. And in addition, the ministry inspector can determine whether the circumstances are such that there was a contravention of the legislation and issue orders for compliance with the Occupational Health and Safety Act. The obligation on an employer to notify the ministry and preserve the scene with respect to workplace accidents applies in any death or critical injury, as I said. This leads to the question of what's a critical injury. So when do you have these reporting obligations? Well, the regulations say that a critical injury occurs where there is an injury of a serious nature that places life in jeopardy, produces unconsciousness, results in substantial loss of blood, involves the fracture of a leg or arm, but not a finger or toe, involves the amputation of a leg, arm, hand, or foot, but not a finger or toe, and consists of burns in a major part of the body or causes loss of sight in an eye. So this definition of critical injuries covers a lot of injuries that are not uncommon. It's not uncommon, for example, to have fractures to a leg or arm in a workplace. It also seems that there's a broad range of circumstances in which the area might become to be considered to be a workplace where a critical injury or death could occur. And this leads to the question that eventually went up to the Court of Appeal in this decision I'm going to get to involving Blue Mountain in a moment. So is an employer's obligation under Section 1 triggered where there's a death or critical injury of a non-worker? For example, if you think of different scenarios, most people, when you think of an accident, think, okay, a worker's working in a plant, slips and falls, or gets hand caught in a pinch point or something. What about non-workers? So regular people who are visiting what could be considered to be a work site. For example, if you're at a shopping center and someone faints at a retail outlet, or if you're in a restaurant and someone chokes and becomes unconscious, or if you're at a sporting facility, someone playing a game of some sort, hockey, basketball, whatever, fractures an arm or leg. What happens in these types of circumstances? Until the Court of Appeal's decision in Blue Mountain, it was debatable as to whether a death or critical injury of a non-worker triggered the employer's reporting obligations under the OSHA. And obviously, employers are concerned. People run shopping centers, retail outlets, sporting facilities, ski hills, that if there's a broad application of Section 51, it would require that there would be the reporting obligation and the preservation of the area of the accident, which could have potential operational difficulties and even business losses. Because as we talked about a minute ago, you have an obligation to preserve the scene of the accident. So that could mean fencing off the area or setting up a blockade, restricting access to it, closing the restaurant, for example, if you're in the restaurant business, closing the mall, the retail store, or in Blue Mountain's situation, it could involve closing a whole run, which, if you ski, is quite a dramatic thing. It can really be disruptive on a ski hill. I ski at Blue Mountain every weekend in the winter, and we routinely see that the ambulances just go back and forth to the local hospital. In fact, our ski club even does fundraisers to support the hospital, because so many of our members have to go there, and they provide excellent service up there, but it's a really big problem. So the potential number of incidents that might fall within the definition of a critical injury at Blue Mountain Ski Resort was the driving force behind Blue Mountain's determination to appeal the Ministry of Labour's order all the way up to the Ontario Court of Appeal. So what happened with Blue Mountain? Interestingly, it was not a ski-related accident that occurred. What happened was a guest drowned in one of the resort swimming pools that was unsupervised by workers from Blue Mountain. So no workers were involved, no workers were injured. And Blue Mountain initially thought the person had a heart attack, later learned that the gentleman had passed away from drowning. And they didn't report the incident to the Ministry of Labour because they felt it was a non-worker and it didn't occur at a workplace. So what happened was the ministry came out doing a routine inspection, which are always unpleasant, and found out about this incident, and after the fact issued an order saying that Blue Mountain was not in compliance because they didn't report this under Section 51. And Blue Mountain was obviously quite distracted about this because they were on a ski hill right behind the pool, And they were quite concerned that non-workers having to report injuries of non-workers on their property would be very problematic for them from a business point of view. So they appealed the decision to the Ontario Labour Relations Board, and the Ontario Labour Relations Board upheld the order. They found that the inspector's order was aimed at furthering the objective of the OSHA, which is the protection of worker health and safety, as we all know. And given that the cause of the guest's death was a swimming pool drowning at a time when no employees were working in the pool area, it was difficult for many to see, including myself, a connection between the incident and worker health and safety. So they were upset about this and brought an application for judicial review to the Divisional Court, and the Divisional Court agreed with the Labour Board. So they appealed it up to the Court of Appeal. Unfortunately for employers, the Court of Appeal disagreed with both the boards and the Divisional Court's conclusions. On the lower rulings, the reporting obligations would be triggered whenever someone died or was critically injured at or near a workplace where a worker is working, has passed through, or may at some other time work regardless of the cause of the accident, the court found. They concluded that such a broad interpretation would result in absurd results. This absurdity was apparent when the reporting obligation was considered in conjunction with the statutory obligation to preserve the accident scene. So it's one thing to have to report and to fill out the forms and do that, but preserving the scene of the accident is very problematic. And what examples were used were, for example, if you have a live televised broadcast at the ACC, and when the Leafs are losing another game and one of the players suffers a broken leg on ice, that is a workplace for people working the ACC, obviously, the hockey players. So it's a workplace. There's an accident that's occurred, and that would trigger, and if you give the broad interpretation, the obligation to cordon off the scene where the person broke the leg and to send everybody home and the game's over. Another example would be an accident on a highway where someone loses consciousness. You've got police officers who work on the highways. You've got road construction people that work. That's a workplace for them. And if you had a car accident and someone, for example, lost consciousness, you'd have an obligation to preserve the accident scene, report it to the Ministry of Labour. It could close highways and stuff. So the Court of Appeal felt that this would lead to absurd results, because there appears to be no causal connection between the injury and any workplace safety issue. So the court held that in order for Section 51 to apply, there must be a reasonable connection between the hazard that caused the death or critical injury and a risk to workers' health and safety. And that requirement is consistent with the OSHA's purpose of protecting health and safety of workers. And what they did was they established a three-part test. The courts love doing this, and lawyers love doing this, because we love giving advice where we can say, look, there's a little check mark thing. You go through each part of the test and apply it and apply the facts and the law, and you come out with a reasonable opinion on it. So the court was good at that. Unfortunately, in our courts in Ontario, often you don't get these tests till you get to the highest level of courts. It's often quite confusing for us before that. But the court in this circumstances established a three-part test for determining whether you had to report these non-worker and worker accident situations. First, a person, either a worker or a non-worker, has been killed or critically injured within the meaning of the legislation. Second, the death or critical injury must occur at a, quote, workplace. The court defined a workplace as a place where a worker was carrying out his or her duties at the time of the accident, or a place where a worker might reasonably be expected to carry out his or her duties. Now, that's a broad definition of workplace. In the example of the pool, there was no one there from Blue Mountain at the time, but it's reasonable to assume that a maintenance person, for example, would come in and put chemicals in the pool and do other maintenance-related tasks. So that could be a workplace. Third, and this is the most important thing, usually the first two are easy to figure out, but there must be a reasonable nexus between the hazard giving rise to the death or critical injury and a realistic risk to a worker's health and safety. So, for example, would a worker in the course of performing his or her duties be exposed to the same risk that caused the death or injury to the worker? In Blue Mountain circumstances, the Court of Appeal concluded that there was no reasonable nexus between the guest drowning in the swimming pool and worker health and safety. The guest had died from drowning. It would not be reasonable to say that Blue Mountain's workers were exposed to that same risk, and as a result, there was no obligation to report the incident to the Ministry of Labour. Now, perhaps the result would have been different if that same guest had died due to fumes, for example, from chemicals that were put in the pool, even with the worker not there anymore, but the chemicals put in the pool, they died from that, they had been exposed to a hazard, and they probably would have a reporting obligation. So what do we take away from the Blue Mountain decision? Well, the Court of Appeal's ruling narrows the circumstances in which an employer's obligations to report an accident and preserve the scene of an accident would apply. For example, Section 51 likely will not apply where a customer loses consciousness at a retail store or due to a heart attack or something like that. On the other hand, Section 51 would likely apply if that same customer lost consciousness because of fumes in the air in the workspace where employees work either at the time or on other occasions. So what's our advice? If there's a death or critical injury to a worker, you must notify the Ministry of Labour as soon as possible and preserve the scene of the accident. So fence it off, stop the operation of the equipment if it's equipment related, keep people away, don't touch anything. And given the potential significant liability, I do a lot of health and safety prosecution defense work, and the fines are astronomical for, they're always unfortunate accidents, but even relatively minor injuries. So we do encourage you to get legal advice right away, because when the ministry inspectors come in, they kind of take over, and you can make decisions that can affect later on that are not going to be to your advantage. Secondly, if there's a death or critical injury to a non-worker, it'll be necessary to apply the Court of Appeal's three-part test. And given the tight timeframes for reporting to the ministry, we'd also recommend that you get legal advice as well, because you need to determine whether, in applying that test, there is an obligation to report. So it'll be interesting to see how the courts will apply the Court of Appeal's new test. This is a very fresh case. It just came out recently, so we'll have to see how it develops in the case law. I want to thank everyone for your attention and enjoy the rest of the seminar.